Hello everyone and welcome to today's Mondac webinar in association with AZB and Partners, which will provide an in-depth focus on the key hotspots which employers need to focus on when the Indian labour codes become effective. My name is Dan Sampaio and I'm joined by a brilliant speaker to take us through today's discussion. Sumit Ghoshal is a senior partner in the NCR office. Sumit is a key figure in the firm's employment practice, adept at navigating complex employment law issues. He provides comprehensive advice on the treatment of senior personnel, drafting employment contracts, and reviewing employee handbooks and HR policies. Sumit's expertise extends to statutory benefits, termination procedures, employee transfers, and business closures, as well as structuring severance packages for senior management. Sumit formulates confidentiality and non-compete obligations and addresses expat compensation matters. He also represents clients in labour authority hearings and conducts training on employment law developments and compliance, particularly regarding Indian bribery laws. But before we begin today's webinar, a quick housekeeping item. You can submit questions to Sumit and the team by typing them into the questions pane of the toolbar on the right-hand side of your page. Sumit will endeavour to answer as many questions as possible during the Q&A session, but please do reach out after the webinar for any additional information you may require. It's now my pleasure to hand you over to Sumit to begin today's session. Thank you.
Thanks for the introduction. I'll just skip over the slide. Aaron, just checking if the slide is up.
Yes, we can see the slide, Sumit. Thank you.
Okay. Good afternoon and good morning from wherever you're joining. Thanks for joining this webinar today, and thanks for the introduction to me as well. My name is Sumit Ghoshal, and I'm joined by my colleagues Atima and Nikhil for this webinar. I think as you would have listened to the description as well as I think the question that arises is, why are we having this webinar at this stage where labor codes are kind of, let's say, I would say, has gone in a limbo, and we are waiting for the rules to be made effective, the codes to be made effective. I think like any other law, there is a time gap between for a code to become an act and then of course the rules coming into play. This time gap that we have, I think, is the best time for organizations to prepare themselves for, because I think because these codes are almost crystallized, there is not going to be any change in these labor codes that we have looked at. It's only the rules which are in the draft form discussion might be taking place, and that might become the rule of the law. But because this time gap allows us to at least study these codes and focus on the most obvious issues that as an employer or as an organization we should be channelizing our energy on. So this webinar is not supposed to be a decoding of the entire labor codes. I think we can of course have those offline detailed conversations. Today I want to focus on some of the critical issues which as an employer we need to focus specifically and see how are we prepared as an organization, whether we can we do some steps better, can we proactively prepare our HR teams, our legal teams, our compliance teams to ensure that we get the best out of the labor codes. Once these codes are effective, the rules are in place, I think we are one step ahead of the pack to ensure the implementation. So I think with that, I just wanted to lay out that the scope of this webinar is towards the hotspots under the labor codes, which we believe are the key critical areas which as an organization we need to focus on. So I hope you can see the change of the slides. Today, what we are trying to cover is, of course, I'll give a very short overview of what is the current Indian employment regime and what are the labor codes all about. What is broadly changing? Then we come to the heart of this webinar. What are the hotspots for employers that they need to watch out for? With each hotspot, we will also focus on as a HR team, as a legal team, as a compliance team, what is in it that we need to take away from, right? What is the potential way forward or a solution oriented approach that we can look at? What is the next step that we need to follow in terms of our organization, right? So big or small, these are equally applicable to any type of organization, and that's the you can say the good or the bad for the labor codes, and we will come across some of those. But slightly pressing upon the fact that this is an important development across industry. It doesn't matter if we are in the manufacturing sector, in the IT sector, in the telecom sector, labor employment issues are going to cut across the sector, right? So with that, I think I'll move to the first part. What is the current regime and why do we need labor codes in the first place, right? So today, labor employment is a concurrent subject, which means both our central and the state at both level laws can be made, which provides the biggest complication that we have, right? Today, we have 91 state laws and 43 central laws. I mean, that's the number we found on the website, but I'm sure there are more. As an organization, let's say if I'm a pan-India organization into multiple states, if those organizations have to, let's say, lay down an employment compliance regime, for us to do that, imagine the cross that we have to look at in terms of state laws, central laws, overlapping stuff. This was the exact problem with these archaic provisions that labor codes are trying to solve for. For instance, let's say some of these arcane provisions do not even cater to modern day issues, right? Uh, we had this entire COVID work from home, everything happened, but definitely at that point, our traditional laws were not adept to look at what kind of issues from work from home that could be examined, right? Or simply this new breed of workers, right? Gig and platform workers that we will discuss today. I mean, there was no particular law, and we were trying to stitch that into the current employment laws. I think these labor codes, even though this has been a discussion over the last 10 years, if I can say so, uh, all of them have been notified and all of them were discussed and debated. But the key problem that they were trying to solve was for the fact that we need to have some commonality of definitions, we need to have some structure, some uniformity, or some objectivity to hold on to so that we can look at issues in one go, right? Which means consolidation of laws, this 9143 laws that you're looking at needs to have been codified in a few. Ideally, we would have had one long big code, but definitely I think this was something that the government looked at the type of issues, and now we have four labor codes. So with that, I'll just go to the labor codes issues as well. So the four labor codes I think that we have today is firstly code on wages, industrial relation code, code on social security, and the occupational safety, health, and working conditions code. I think these four codes that you are seeing, right? As you can see the year, they have been notified by the central government. It's in the gazette, so these are not going to change. Again, repeating, these are not going to change. It's just that the rules which are going to come under this and the state laws, they might have some provisions which can add on to this. But what does code on wages do? It consolidates all the wage related provisions, right? What does industrial relation code or the IR code looks at? It is going to look at the framework of disputes which happens in the industry or any industrial dispute which is going to take place. Kind of reminds us of the ID Act, Industrial Disputes Act, but the framework of IR code is much more than that. Then we have the code on social security, right? That consolidates 9 existing social security laws. Your PF, your gratuity, uh, your bonus, everything is going to be subsumed under code on social security, and that is going to be, one of the most important codes going forward. And lastly, the occupational safety, health, and working conditions code. These are again going to be an amalgamation of 13 existing laws. These are looking at health and safety, what kind of working conditions are laborers for, and all that. Now, the important point is it's not that these codes are bringing in the entire new regime. It's not that. You will see, I would say, 75% of old traces of the old law. But what they are trying to do is because they are going to be put into one big code, at least you do not have the multiplicity of laws that we are dealing with today with center and state. For instance, if you need to make a register of attendance, at least it's common for multiple laws in one go, right? So these are some of the key issues these codes are trying to solve. Today we'll focus on each of these codes. What are the key hotspots that we as organizations should focus on? Yeah, so slightly more info about the codes. There are 29 national level labor laws which are getting consolidated here, right, in these 4 labor codes. Very important what you see in red on this slide, right? The state laws are going to remain as it is, right? So the question in our mind is this really solving a lot of stuff? The center and state problems that the overlapping problems we spoke about? Probably yes and probably not, because yes, it does help in consolidation of all central laws at least. But unfortunately, the state level labor laws will continue as is because we discussed it's a concurrent subject. So even a state can make a law on that today. How labor codes are structured, by the way, the code is almost equivalent to a legislation or an act or a statute. And under that, states also will get the powers to issue their own rules. As of now, a lot of rules are in the draft form. So you can go to the websites of labor and employment websites of each of these states and you will find these draft rules there. For political reasons as well as some social reasons, center and state tensions, I think these are still not seeing the light of the day, these tools. These codes also solve some of the contemporary issues that we spoke about, right? There is recognition of gig economy. There is a new approach which has come in, which is inspector and facilitator approach, right? People old in industry will remember Inspector Raj or Inspector regime, which means I was forcing you to take a license, otherwise I will not operate. I think this code is trying to change that image, and it is saying that I will facilitate licensing, registration, all that, and help you better comply with the codes rather than going penal backwards against you. The important point is in certain laws of the country, in terms of sexual harassment or POSH, as popularly known, Apprentice Act, Transgender Act, Person with Disabilities Act. These are legislation, though central in nature, will continue to be applicable on the side. The code does not kind of turn around with these legislation, and we'll have to see how we can harmoniously interpret this in light of these 4 big codes. So I think we spoke about central and state level conflict. If you see this slide, right, this is just an example of that. Now, labor codes are solving a lot of things. That's are going to be only source of truth for an organization. Definitely helps the HR legal teams to look at and quickly draw a compliance chart. The problem that we have today, and as an employer we need to focus on, is the state laws are also existing. We need to also comply because at the state level, we are registered there. We will have a shops establishment law which is going to be applicable to us. The local laws, national festival holidays, the local rules there. So just one sample here. If you look at labor codes here and let's take Haryana Shops Establishment Act as an example. If you look at the comparison, right, there is 8 hours, shops establishment follow 9 hours. Overtime, it's 125 hours in a quarter, or let's say 40 hours in a month, but shops establishment says 50 hours in a quarter. Labor codes are giving you encashment of leaves, but the state law say, okay, you can only encash when you resign or terminate. Now, or a casual leave, right? Let's say 10 days as per standing orders or 7 days only for shops establishment. What this slide is kind of talking about is the fact that it's not enough, even after labor codes comes into today's, let's say it gets effective 1 year down the line. Even today, you will have to focus on state specific laws. Now, our only belief, I mean, and as people in the industry looking at employment laws for last decade, we can tell you, I think what is going to happen though is, I think the state will study their shops establishment and the local laws, try and harmonize that with the rules that they are going to prescribe under the labor codes, so that there is some kind of harmonious interpretation that one can draw, right? And one is not left in a situation like this. Should I follow the central law? Should I follow the state law? And the thumb rule of labor law is, if you have anything to do with a workman or an employee, we need to give him the beneficial treatment, right? Now, it's easy said than done, because as employers, you also have to balance cost and compliance. So there's going to be a tricky situation when both the state law as well as labor codes are in effect. And therefore, we need to, it's not that labor codes are going to be our only source of truth. And that's the point we need to be careful. So with that, I think I'll come to critical hotspots, right? What we believe are some of the key important points. These are not the end of all. There are going to be more hotspots, but these are some of, I would say, the top issues that we need to start thinking on. So the first impact that we are looking at is wage-related impact, right? And some of you would have read, and this has been discussed. Now, this is what a wage under labor code looks like, right? The definition of wages divides the wages into two parts. It says all remuneration, which means anything I want to give to the employee for coming to work and doing his job, by way of salaries, allowances, otherwise, right? Big term, all encompassing terms. It includes basic pay, a DA, a retaining allowance, and I'll come to the last two bit specifically on the inclusion, but it excludes everything what you see in the cross channel, right? Any bonus payable under law, important, house accommodation, PF contribution, conveyance allowance, anything to defray special expenses, HRA, overtime, commission, gratuity, retirement compensation. So this definition will look very, very familiar to you with the wages definition we have even today. The benefit which the codes are giving here is the fact that you have one single definition now of a wage, right? You don't have to go to the PF law to see what is the wage definition, what is the inclusion, what is the exclusion. You don't have to go to gratuity. You don't have to go to, let's say, an ESI. The wage is one single particular definition. What you see here, though, in the purple inclusions, interestingly, the law says that if, by the way, your exclusion on this side is more and over and above 50% of the total remuneration, then that extra 50% remuneration has to be reclassified as wages, right? And so before this, I mean, before the courts came in and all that, we would have heard a lot of issues of Surya Roshni and a lot of kind of a labor law compliance issues. What was happening was all employers or organizations were trying to, of course, you can say betterment for the employee or not, but they were trying to do a salary structure in a manner where even the basic pay was going below 50%, or somewhere it was, we have seen some of our clients, it was as low as 30%, 30 to 40%. The problem with that structure was the case laws and the authority was saying, by the way, your basic pay is artificially low because you don't have to pay on PF and gratuity, because then your basic pay becomes your central computation methodology for all other payouts, right? What this reclassification of 50, over and above 50% is doing is, it is attacking the very issue that the labor authorities have been harping upon, that if you are trying to be cute and doing a CTC or a salary structuring in which your basic pay is even going below 50% of total remuneration, your extra exclusions that you have, people would have structured in some allowance or the other, it will be reclassified and we will be put back into something like a basic. So let's take a practical example of that, right? if you see on this slide, right, what is kind of appearing, this is a sample salary structure, pre-labor code and post-labor code. Most of the figures are absolutely same. If you look at a comparison between the two and the total exclusions, and when I say exclusions, all the allowances and everything is 1,40,000 in both cases. If I add up the total remuneration, it is 2,40,000. Now, if I had to do a PF wage calculation, I would have simply done something on basic wages. So PF wages for me on which I have to compute is only 1 lakh rupees. What post labor code is saying is, by the way, if your total exclusion, which is 1,40,000, is more than 50% of your total remuneration, which is 2,40,000 in this case. 50% of 2,40,000 is 1,20,000. So what is the extra that is getting figured out here is 20,000 extra balance is being, if the reclassification component becomes 20,000. 1,40,000 the differential and 1,20,000 50% of 2,40,000. So what the wage code is saying is, if you are trying to be cute and you are putting everything in your allowance bucket or your, let's say, exclusions bucket, we will only allow that to happen till 50%, right? This 20,000 will then re-characterized as basic pay, and then your PF wages will include from 1 lakh to 1,20,000. So naturally, the contribution 12% of, let's say, 1 lakh is 12,000 earlier, will rise from 14,400 just by reclassification of this wage, right? So this is just a sample calculation of what is the impact solely on the PF thing. I'll just take a pause to just emphasize that my original PF contribution was 12,000. Due to the 50% rule that has been brought in, this has come to 14,400. And one thing in the last slide, I also didn't spoke out, if you are giving any in-kind remuneration, right? You are kind of looking at, let's say, some kind of a club benefit or some kind of something which cannot be monetized. The law is also saying that will also get recharacterized. So now, what is the other impact on wages that is getting up? Firstly, as employer, as private organizations as well, we need to be very, very, the compliance bit which is going to crop up. Today, a Payment of Wages Act is only applicable to a 24,000 employee, right? But going forward, the code of wages is going to be equally applicable to all sets of employees, irrespective of the threshold, which means that any increase in the scope of applicability, both on the employer side and the employee side, is going to increase, right? Let's say time limit for payment of wages to employees, that needs to be done in 7 days, right? You cannot have a wage date of, let's say, I will give you on 15th of every month. No, you will have to give on 7th. It can't be lower than that, right? By the way, if I'm resigning or I'm being terminated from the establishment, I need to be paid my dues, full and final settlement within 2 days, right? Very, very important change within 2 days. Sounds impractical, but that is what the code is prescribing, right? Again, what is also changing is earlier there was Equal Remuneration Act. It was a simple thing to say men and women need to be paid for same or similar work. What the change has been brought in is now there is the word gender, which means even other transgenders or other kind of genders apart from male and female are going to be included, or it's an inclusive approach. I think we talked about uniform definitions, so I'm not going there. Floor wages, another very, very important. When we look at today minimum wages, we are usually looking at state, any notification the state has looked at. Going forward, it's the center who is going to prescribe a floor. When I say a floor, the state cannot prescribe a minimum wage which is lower than what the center is already prescribed. Which means, I mean, it could be a political tussle as well, but at least the center will decide what is the minimum benchmark. So as compliance team, we will also have to look at what is the floor wage going on at the moment. And with the consolidation of these codes, while the definition of employee and worker were always, let's say, I would have seen a definition of employee in a PF and a worker in an Industrial Disputes Act. Today, if you see these codes, they are also using employee and worker in the same code. And so what we can tell you is specifically that employee is still a broader bucket. Out of that employee bucket, a subset of that is going to be a worker definition. And we'll come to some of the worker definition that they are prescribed, but a worker is always a subset of an employee, right? The same concepts still holds true. If you are in a supervisory capacity of 15,000 or 18,000 some codes, you are still will be outside of a worker definition. But as when you are looking at compliance, it is important that we identify where is the word employee used or where is the word worker used, because the code are using both terms, both might have different ramifications. So it's important that we look at some of these definitions while we are decoding the codes. So what is the key takeaway, right, for the impact on wages? Firstly, as I said, there is no more the salary thresholds of the past that we are looking at, right? I mean, we don't know whether the rules might bring that in, but as of now, the general rule is it's kind of applicable to all categories of your employees, right? So if you have one definition of wage across industry and across the category of employees, you'll have to follow that. Secondly, both HR and legal teams, I think, need to sit together and review the current salary structures. Very, very important, because we need to start assessing. And I think the compliance should start today. That do we, with this new reclassification rule, what is going to be our impact? And the very important point here is that while we showed you a sample impact on PF, if your wage definition gets reclassified, right? I mean, if my 50% of my all allowances and all exclusions gets reclassified, there is going to be a knock-on effect on everything which is dependent on wages. Be it gratuity, which is 15 days of wages for every 5 years continuous service, be it retirement compensation, again 15 days of wages. So the common theme is it is the computation is on wages. If my wages component go up, definitely all these payouts will kind of go up. Now, in corporate organization, we have this concept of CTC, right? So if I had promised a CTC of 100 rupees, as employer organization, where am I going to manage this increase in wage, right? Am I going to increase the salary again? I don't know, because then this is a debate that HR and legal teams need to already start having. And under 50% as well, it's not that you can play around with allowances. It's not that only after 50% the allowance gets reclassified. No, within 50% also you need to ensure that if there's something like a special allowance, which has been really, I mean, it has been debated to death by the Supreme Court, that this is nothing but a residuary figure by organizations to ensure you get what has been promised. And it's not an allowance, but basic wages in allowance form. So even a non-genuine allowance like that will also get reclassified irrespective of the 50% plus. And the last takeaway, I think, which we believe is going to be very important, because some of these payouts are on a month-on-month basis, right? I need to give PF every month. If my wage is getting reclassified, but I'm, let's say, giving you a bonus in the month of March, what happens in the month of March? Will I go and reclassify? So my salary for the rest of the months, but in the month of March will look very different. My PF will become different. My gratuity will become different. So it's very, very important that one-time payouts are also examined as to how they will be treated as far as reclassification comes. Right? So these were important takeaways. Second, I think hotspot we have to be very careful on is gig and platform workers. Now, a lot has been said about these concepts. I think to simplify stuff, right? I mean, for gig workers, and they use this term that gig workers are nothing but a person who performs a work outside a traditional employer-employee setup, right? So if I have called some person just to do my work for some, let's say, few hours, a few days, he gets the work done and kind of goes back to his owns stuff, does other works for other organizations, but kind of he decides his own fate. Such a person is called a gig worker. And I would say the most easiest way of understanding a gig worker is anybody I'm hiring to do a particular job, and that's the end of it, right? I mean, so just giving some example, let's say if a company hires a particular photographer, individual photographer to do a event and then go back, that is nothing but a gig worker, right? Because once one job is finished, another organization can pick it up and he can do the job, or for a repair work. Now, once this gig worker kind of is engaged through a platform, right? And when we say platform, is a platform where other organizations are trying to look at, do we need workforce to do our extra jobs, right? So something like a freelancer, right? If I can do a graphic design or web design and I've been logged onto a platform like a Upwork, organization can contact me saying, okay, can you just design the homepage and here is the fees, and then after that we have no issues or we have no relationship with you. So a gig worker coming through a platform connected to our organization is called a platform worker. Now, what are the important points here we need to kind of look at is a gig worker is and a platform worker, they were all part of a workforce industry which traditionally organizations were not caring for. And what these labor codes have tried to do is recognize this set of workers and say that, by the way, organization, if we are using this, then there is some kind of a social responsibility casted on you as well. And we'll just come to that. What central government is going to do for gig and platform workers specifically is they are going to say that for your social security, for your accidental needs, for your life disability cover, we are going to ensure that you need to have some kind of a social security benefit given to you. And these there are going to be schemes floated by the central government. Now, as far as what the labor code is saying today, the funding which will come in these schemes are going to be, it could be from the center, it could be from the state, it could be from CSR contributions by the company and aggregators as well. So this is a new term which under labor regime which has come in. Now, who is an aggregator? Aggregator has been recognized as a digital intermediary who is connecting as a buyer with, let's say, a service provider or a seller. Now, the schedule of these labor codes give a particular list of, I would say, who can be the aggregator. But I would say that is while it's an inclusive schedule, it's going to, I mean, the most easiest way of thinking of it is, let's say, all your marketplaces today, all your, let's say, Amazon, Flipkarts, or your urban company, anybody who is connecting these gig workers, or let's say you are delivery agents being classified, they are going to be classified as aggregators. Now, why is this concept brought in? Because the government and the labor code are saying, if you are using the service of these of these gig workers and all that, you have a responsibility towards them. What is the responsibility? You need to contribute something between 1 to 2% of your annual turnover, subject to a cap of 5%. So it is going to be a huge number if you look at if they are talking about annual turnover. This money is going to be funded into the schemes and the corpus for which this will be prepared for. So if you are an organization who are classified as an aggregator, we should start thinking, how are we going to plan for this? Do we need to do something about it? And today, as of today, state of Rajasthan has already come up with a gig and platform law of their own, which adds to the problems that we already have. Because we will have a central law and then we will have a state law. Even state of Karnataka is already in the pipeline to have a bill on these, and I think other states will soon follow. So the important takeaway is, by the way, I think it's important that we work with our HR teams and anybody to, or even teams across the board to look at, are we hiring gig workers or not? Because these gig workers going forward are, they might require to be registered with a particular, there's a Shram portal there which has been prepared for them. By the way, if we are in any way classified as an aggregator, then I have to start thinking on the financial impact I'm going to have. 1 to 2% till 5% of this amount is going to be a huge impact when we are asked to fund these schemes. So very, very important that we recognize and start taking steps on gig and platform work. The third hotspot, I think, which we believe we need to all concentrate on is industrial standing orders. Now, when we speak of industrial standing orders, we kind of imagine in our face it is a factory and setup is going, and they and the workers, it is for them that things need to be applicable for. I think this mental model and this notion has to change. There were already some traces where standing orders were extended to IT and IT industry in a few states, including Haryana and Karnataka. They said if you are 50 or more workers and you are in the IT establishment, you need to start complying with standing orders. Now, and let me just finish with the code. So every industrial establishment, what the code says is, if you have 300 or more workers, remember the definition we had, workers are different from employees. A worker is a smaller subset. If you have 300 or more, you need to adopt a model standing orders, and that needs to be certified and has to be brought within a period of 6 months. Now, worker definition might change from code to code, but it's important that we understand that it's no more that it's only the factories of the world and the industries of the world that need to adopt. Even let's say something simple as an IT industry or IT enabled service, we need to start adopting a standing order. Now, standing orders in the past have been drafted in a very, I would say, industry backward way. You could look at, I need to give you rest time, I need to have a canteen, all that, very, very factory oriented. But now what the courts are trying to do, and some of the draft standing orders that we have seen, especially for the service sector, which has already been issued, is in draft form. They're already providing for new age concepts, like work from home, payment of wage to be done electronically. If you are in the IT, ITS, what is going to be your working hours? What is going to be the misconduct, which has been a bone of debate when we are firing someone. So standing orders are not your old rudimentary standing orders that we thought in the past are not going to be applicable just because we are in a private. So what is important in standing orders, key takeaway is from today, and not just for standing orders, but please start classifying who are your employees and who are your workers within that. It's very, very important because 300 is not a big number for a big organization. If you have 300 workers or more, industrial standing orders are going to be applicable to you. Second thumb rule, not just for labor codes, even today, do not go by designation, right? If somebody says, oh, by the way, somebody is in a supervisory or managerial capacity and he's earning more than 80,000, he's not to be considered as a worker. Just because we have given him a designation as manager doesn't mean he does not become a worker, right? We need to look at the roles and responsibilities performed by that person. Thirdly, I think HR legal teams have to examine what are the aspects covered in standing orders. Now, today, if I'm a private organization, I will just have an employment contract, some handbook, some policy, and done away with it. But if standing orders now come into play, I have to reconcile an employment contract and a policy with those standing orders. So now, as an HR team and a legal team, we need to take a judgment call on, and even the compliance teams as well. How do we ensure that there is a sync between our employment contract and, let's say, a standing orders which has been prescribed, right? If the standing order is giving more beneficial terms than the employment contract, definitely we'll have to go with the standing. And of course, if standing orders are going to be applicable to you, we need to quickly start moving, look at do we need to modify standing orders as per our industry or organization, get it certified and start complying with it because the penalties are going to be significant. So fourth hotspot, I think, which organizations should look at is specifically fixed term employment. So again, there were already traces of fixed term employment in the previous laws as well, but it wasn't very well recognized. Only some standing orders making this mention. Now, Important point is fixed term employment is kind of formally recognized now. What it says though is that if you have a FTE in your organization or a fixed term employee, he needs to be given equal benefits as a permanent employee if he is doing the same or similar work. Right? So if I have an accountant who is permanent, and if I have a fixed term employee who is, let's say, for 2 years with me, I need to ensure that any other benefit, if I'm giving canteen stuff, if I'm giving some allowances, has to be same. This is a very, very important change for us, right? And secondly, what the codes are saying is, if there's any benefit under law which is available to a permanent employee, which was kind of based on the duration of service, something like a gratuity, which earlier I think it was very easy uh, for a person to be said you will not get gratuity because you haven't done 5 years of continuous service. But today, as we stand, if a permanent employee is a fixed term employee is kept, if let's say he only works for 2 years, I need to proportionately give him the benefit under law that is made available to him. So any period of service related benefit has to be given to a fixed term employee for a benefit available under law. So what are the key takeaways here? Please start recognizing who are your first fixed term employees, right? You need to kind of assess what is going to the financial impact, right? Because today I might not be giving a lot of benefits to the fixed term employee, which I'm giving to a permanent employee. So very, very important that we start looking at comparing the two aspects. I think we have seen in the past that people were keeping fixed employee for 4 years, 5 months, terminating and again renewing the contract. Why? Because we did not want to give them gratuity. This kind of relooks at that. So as HR teams, we'll have to again look at totally doing away with this practice because a fixed term employee is also going to get gratuity. Again, compare the permanent employee benefit of a FTE and try and see whether their employment contract needs to be revised totally. The fifth hotspot, I think, quickly covering is the contract labor arrangement. Now, contract labor arrangement, I think we all understand principal employee, contractor, contract labor being deployed. That's the three-party arrangement in a contract labor scenario. The good news, if you can think of it, that the threshold for applicability of a contract labor has been increased from 20 to 50, which means unless I have 50 or more contract labor deployed on my site, my contract labor requirements will not get triggered as a principal employer. So very, I would say, important that we recognize this threshold, and if we believe we are within the 50 going forward on the labor codes, I think we should be good enough. But what is now really changing for contract labor is that this concept of core activities has been brought in, right? Which I think was there in only few states like Telangana and Andhra Pradesh. There, I think what was happening was, so what the labor codes is now saying is, if you are hiring a contract labor to do your core activity, which is a defined term by the way, then you are prohibited to get contract labor on your premises. Which means, let's say if I'm a entity, let's say preparing software, and I want to have some contract labor doing the work as software development as well. He continues for long in my organization. Because my core activity is software development, I cannot have a contract labor doing that work. So it is a big change, and this is going to impact a lot of industry who is kind of banking today on contract labor to do some of their support jobs. Right now, it's not that they have not given carve outs. The carve outs are, let's say, if these establishments are functioning through contractor, I think then we can look at that. Some of the activities which do not require full-time workers, I think for major portion, again, subjective call, but again, some carve out and certain increase of volume of work, right? I mean, if I have a manufacturing plant, I need production to be stepped up during Diwali. I think that can be done. But my key takeaway for this, I think, is going to be this increase in threshold has to be looked at. Are we falling within 50 or not? please check applicability of this contract labor to your organization. Now, HR teams should kind of sit with the management and decide going forward what will they call as core activities. Now, sometimes you have a group organization which has entity-wise structured, right? So each entity's core activity will need to be seen for this to be implemented, right? You cannot have a core activity of the group and start catering with the ancillary stuff. No, each entity's core activity, and maybe we'll have to depend on the memorandum association to look at the main objects of what we have classified. Again, we need to look at whether the contract arrangements for deploying contract labor has to be relooked at because of the new definition of contract labor, which has some kind of exclusions there. So please have a look at that. And then the financial impact, both ways, right? If you cannot keep contract labor, which means I have to hire more employees, so that is the financial impact. Or if there were people who were kind of in your organization for a long time, but as contract labor, and they can say, this person was my employer for long, there is a risk of absorption there. So these are very, very important takeaways for, I think, other hotspots in industrial time I'll quickly go through. Uh, yeah, there is a worker reskilling fund which has cropped up as a new concept under labor codes. And the labor codes provide that if you are retrenching an employee, by you also need to pay 15 days wages in this reskilling fund. What I think the labor codes are not per se clarifying is that is this in addition and over and above the 15 days retrenchment compensation I need to make to a retrenched employee? So need to assess, is this additional financial burden for every person I terminate? I also need to contribute 15 days wages to a reskilling fund. Then there's a concept of negotiating union or council, which has kind of been brought. If you have a trade union, if you have one trade union or more trade unions, you need to have a negotiating union or council recognized as well. Appointment letters have to be issued in writing because now there were things in the past that I think with few offer letters and all that we would have gotten away with. But now proper appointment letter needs to be issued. And the last point, I think it's very important that earlier the retrenchment procedure was, of course, under the ID Act, depending on the amount of workers and employees you had, we could have looked at. This has been increased to 300 plus employees. So till 300, you do not need a prior permission for the government to fire employees as well if you have your workforce strength as 300 or more. But I think it's important that we understand that some of our trade unions at the moment are voicing their concern that 300 is a big number, which means organization can fire people at will and not really take prior permission, or they can do mass retrenchment and not really be answerable to that. So these are some of the other critical hotspot, depending on the kind of sector you are in. You are in the manufacturing, or you are in the mass production centers, you have large number of workforce. These are important points to be kept in mind. I'm just going to quickly wrap up. We have time for some questions as well, but very quickly glancing to the fact that monetary penalties have significantly increased. So beware of that. Those are financial impact. On the good side, we have some of the aspects have been decriminalized. So it's just fines, just dollars and rupees, and not really jail time. It's not that imprisonment has been totally taken away, but again, a good part for ease of doing business, compounding options have been made available. So even if I've done something wrong, this is the first time I can compound an offense. And there's a limitation period which is now recognized for labor disputes and labor issues. That is from 3 to 5 years. I think we'll have to see from court to court what is applicable. But generally, it's around 3 years. The employer and the employee can bring up an issue within those 3 years. So, very quickly wrapping, as HR and legal teams, what is that we need to quickly look at, right? These were some key hotspots that we thought we need to highlight it to you. Please start looking at what are your payroll systems talking about, have we started categorizing your payroll system? Are they recognizing who is a worker, who is not a worker? What is their salary threshold? Are the IT system giving us a trigger point saying when have we crossed 300? Even the compliance teams have to be trained to ensure that they need to start applicability checks from day one, right? As I said, the definition of employer and employee from each act to act is now general, which means all your schedules and are of the things of the past. And we'll have to start looking at all these codes are applicable to, I would say, most of the employers and most of the employees. So it's not that I'm sitting pretty with, let's say, a workforce which earns less, things might not be applicable to me. So these are some of the key way forward we should invest our time and money on and start thinking this opportunity that we have between the courts getting notified as well as the rules come into play, because this is not a small change, this is a big change and we'll have to ramp up quickly when the changes happen. Okay. So Aaron, I think we'll take up some questions for now. I think if you have questions, I think we did get a lot of questions during pre-webinar. We can take up those, or if you have additional questions, we can look at that. I think, as you said, yeah.
Thank you very much, Sumit. And just before we move to our Q&A, whilst you're taking a look through those questions that we've had in, I would just like to say thank you very much for your presentation today, Sumit. Very interesting, very informative, and a very important topic as well. So thank you for that. And I'll hand over to you, Sumit, to take those questions that have come in for us. Thank you.
Yeah. So I think one of the questions on work from home and saying that this is not exactly new and all that. I absolutely agree. I think work from home is not exactly new, but the problem that we were having was, let's say if I have to define 8 hours of work, if you are, let's say, in an IT organization, you have the people software and everything, you can tag, right? You can exactly know when a person is logged in or logged out, right? But in a slightly not so tech savvy organization, these are going to be very difficult challenges as to how do we implement the working hours, how do we give somebody overtime, what is the kind of review that we are looking at. So work from home is going to be a very critical, I think, as we saw post-COVID, this is the demand from the workforce. It saves cost as well for the employers, but yes, I mean, we have seen some productivity issues as well. So it's not new, but the fact that now it is formally recognized, employers can also start taking actions if things are not there. It's easy for us to comply with those. Yeah, I think I'm seeing more questions. Any definition of trainee or intern? I think, see, intern, as I said, Apprentice Act kind of continues to be applicable on the side. I think, therefore, I don't see the labor codes changing too much on that concept. Retirement compensation, should it be on 15 days salary or total 100 salary? So, see, as we explained, wages are undergoing a big change, right? So, yes, it is still on 15 days wages. The word is wages, but wages has its own inclusion and own exclusions. But to believe that 15 days wages are getting reclassified, we need to look at the higher number. So it's important that if you have a special allowance sitting in your biggest bucket of the CTC, that needs to be recharacterized as basic, and then you need to calculate 15 days of wages. Okay, just a second, I'm just glancing through more questions.
Thank you very much for sending those questions in. We still have a bit of time, so if you do have any more questions, we will send
Yeah,
those
I
over.
think under section 9 of IDA, consent necessary. I think the consent is still not a mandate. If you are changing work condition and all that, definitely you don't need still consent. There is a consultative approach which has been recognized with the negotiating council or the works committee. I think you should look at that. but it's still not a consent that you need on the 9-year bid. Yeah, I think there are many questions on people sitting outside giving work to folks in India and doing work from home. See, I would say this is a common issue, and it is important. It is not just a labor and employment issue, by the way. You can have tax ramifications as well if he's closing contracts for you, negotiating stuff for you. Uh, a work from if your establishment is kind of not in India, sitting outside, probably you're safe. But then again, you'll also have to watch out for, am I doing really stuff which kind of is going to be registered or requires registration in India? Just by sitting outside giving work, am I dividing the employee from social security benefits or not? So these are going to be important considerations. But yeah, if you are giving work from outside India, broadly from employment law, things might not get triggered for you. Yeah, 300 employees is the size of your workforce, not the employees you're getting retrenched. So whenever you have to see approval requirement, you should see your size of the workforce. I think there are questions also on, like, for IT industry, are there anything specific? I think as we spoke about the fact that there are no specific standing orders for the service industry. My humble request is please go through those standing orders, because it's not your day-to-day employment contracts how they look like, right? And therefore, it's important that we kind of look at those standing orders, especially for IT and service sector, because that is one industry which did not used to see standing orders in the first place. I think we have those old questions also. Oh, this is a interesting one. Do we have an anticipated enforcement date of the labor codes? It's it's very difficult to answer. I think we did see some traction. We are seeing news reports in the newspapers that they are working towards it. But I think till the time they don't solve for this center and state political issues as well, and the rules are not really prepared. I don't see labor codes, getting notified without the rules, because labor codes are such a subject that you need implementation from day one. So you need to have the forms ready, you need to have the registration ready and everything. And so it also requires an IT system overhaul from the government side. So unfortunately, we don't have a clear-cut answer on when the labor codes will there. But as I said, labor codes are crystallized. So you need to start doing preparatory compliances for your organization. Nothing stops you from doing that from day one, because that is going to come either in next 6 months or 1 year. Labor codes are exactly the text that they are. Changes are going to happen in the rules. Sorry, I'm just seeing more questions.
That's okay, Sumit. Take your time, but I think we probably have enough time for one more question before we wrap up today's sessions. Thank you very much.
Yeah, I think again there are more questions on retrenchment procedures. I think you should definitely look at that particular chapter of labor codes. 300 plus is the entire workforce. It does give the help of benefit. Earlier it was 100, so you have a additional window of 200 employees as well, 200 workforce as well. But I think just take it with a pinch of salt, say, because trade unions are already jumping that 300 is such a big number. That means people can fire doing mass retrenchment under 300 as well. So uh, maybe we'll have to be, I think that retrenchment has to be planned in a way that it doesn't backfire on the organization as well. Even though you don't have to go to the government for approval, we have seen retrenchments, mass retrenchments, especially going back. So yes, the good part is we don't require approvals, but still a tricky issue of mass retrenchment.
Brilliant. Well, thank you very much for that, Sumit. Unfortunately, we've just hit the 60-minute mark, which means we need to finish for today. But I would just like to say thank you very much to Sumit and the AZB team for your presentation today, for your thoughts, your insights. Incredibly informative. We really appreciate your time. And thank you also to our audience for being with us today. We really appreciate it. Please do get in touch with Sumit, with AZB. We will be following up with a recording of the session, including Sumit's contact information. So we've got a lot of questions in today. If you had a question that wasn't answered or you want to elaborate further on, please do get in touch. But for now, I will thank you again for coming. Thank you, Sumit. It's been a pleasure spending today with you, and hopefully we will see you all soon. Have a lovely rest of your day. Goodbye.
Goodbye. And thank you for all for joining. Thank you so much.